not really technologists, and half of them are not necessarily functioning as attorneys. But I think between the 5 of them, we've got a pretty good cross-section of what it is to be a lawyer or a technologist, or a lawyer technologist, or a lawyer working with technologists, or a technologist working with lawyers. It's a very vague new animal that I think we're creating here, and these are the first generation of this new animal, I think. So Dazza, it's yours.
Great, thank you very much. So we're going to be setting up some little technology as we go, but I'll have a slide that will help to facilitate the panel. But this panel is titled, I believe, Lawyer as CTO. And as we've talked about how to bring out the topics from that title in the context of what it would be like to live in a world that's a geek house, functionally. What we realized is the best thing we can do here is model what that world looks like even within our panel. And so there's an agile, of the moment, what Jonathan called an unpanel kind of nature to this, and that's by design. And so this will be somewhat flowing, and really just encourage people to participate as we go. So the way we're going to do it is the panelists are going to talk a little bit about themselves and their journey, how they went from, in a sense, Bleak House to Geek House, and have emerged as technologists who also continue to use the lens of the law very meaningfully in this information age. And then we'll tune some of the particular topics to the moment. So with that, I wanted to start with Andrew McLaughlin, if we could. Andrew, could you introduce yourself and talk a little bit about how you escaped Bleak House?
Yeah, so I'm Andrew McLaughlin. I guess I'll do a quick narrative. So law school clerk, law firm in DC where I did appellate litigation, randomly ended up in the big internet free speech case of the 90s, which was the Communications Decency Act case, in no small measure because I'd grown up in North Dakota, and when I got to college I was too poor to make what at the time were expensive long-distance phone calls to be able to keep in touch with people. And so I discovered sort of serendipitously that there was this thing called email on the VAX terminals in the basement, and my college was hooked up to BitNet, and we were able to, I was able to keep in touch with, like a friend at Reed and another one at Oberlin, and it was like nirvana. Anyway, I got to know how the internet worked at a pretty young age, and then that led me to being a lawyer on this free speech case. Went up to the Supreme Court. It was 2 years of my life, and at the end of which I knew that being a lawyer at a law firm sucked and was not for me, and I wanted to get out. So I kind of transitioned by way of a job up on Capitol Hill for a year working for Henry Waxman, followed a girlfriend up to New York, ended up about 6 months later, jobless, single, living in a rat-infested sublet in the East Village with all my crap in Chelsea mini storage, and the pivotal moment of my life.
This is a much more interesting story than mine's going to be, my goodness.
You're just going to have to amp it up, man. No, you're just going to have to outdo me. So anyway, so this pivotal moment of my life happens when I finally really got on track, which was summer of '98. I'm lying on the floor. I can really remember this moment. It was super hot outside. I was shirtless, in all candor, possibly listening to the Smiths and generally feeling crappy about my life. And I get this phone call, and it was Larry Lessig at Harvard, who had just landed this big grant from the Berkman family to set up a center. And so I gravitated up to Harvard as a fellow and immediately started working on this thing called the IANA, which was an organization that managed domain names and IP addresses. Within 2 months of me being there, the guy who stood behind the IANA that I was helping as a lawyer, just as a friend lawyer, went into the hospital with a heart attack and died. And so I happened to be around to launch and then run for a couple of years something called ICANN, which is the Internet Corporation for Assigned Names and Numbers, very serendipitously, but that's where I went deep on the networks of the internet and got sort of a PhD level education in these very peculiar little subjects that have never been even remotely useful to me ever since. But if you need me to configure a router, I'm your guy. And that led me to burnout, go back to Harvard, go to Google, where I ran the policy shop for about 6 years, then the White House with Beth. Well, first the transition with Beth, and then the White House with Beth for 2 years, and
he
then
was wearing his shirt.
Shirtfully. And then I moved to New York, and since I've been in New York, I've worked on Code for America. I spent a year at Tumblr, and now I'm a partner at something called Betaworks, which builds tech startups, and I'm CEO of Digg and Instapaper, which are two of the companies we have. And that's how I got to where I am. And I guess my message to everybody is you can and you should escape from being a lawyer. And the best way to do that is to actually get some technical skills and learn how to build stuff and learn how to make things on the internet. Very, very useful. And at the same time, I'm delighted to have a law degree. It comes in handy every day.
Okay, great. And so so part of what we're doing here is we're sort of navigating and wayfinding as we go. So at the end of the story, the narrative, people are popping up naturally and also somewhat by design, topics, that we want to emphasize. And so for you, let me just tell me if I got this right, Andrew. It's the topic in a sense would be how to build the skill set to transform from lawyer to technologist, or no, I didn't quite capture it. Or how would you put it?
It's okay. We can move on. We'll come back to it.
Okay, so it'll be behind you. Beth Noveck.
Hi. So I will. It's hard to top that one. I'm going to do it. I'm just going to hack the whole thing and change it. But I will give you a little trajectory on this. So I actually have a background in political science originally, and went. In college, we had to write a senior thesis, and I was looking around for topics that I could do that nobody else knew about. And my grandparents had been chicken farmers in New Jersey, and my parents thought it was an excellent idea that I should stay home in New Jersey and do intensive research from their living room. And I decided that was a terrible idea, and I would rather, in fact, go off to Vienna, Austria, wear black, sit in cafes, drink coffee, and do work on 1920s Vienna and the very fragile time that we tend to think of as Weimar Germany and Weimar Austria. So I developed a fascination with what makes democratic culture work and what makes it fail in the case that it did then, and developed this interest in how do we actually think about fostering a more effective and stronger and more robust democracy. So, coincide with this at the same time, what I'm also doing is something also about the unaffordability of phone calls back home. My mother was a travel agent on the side, and so she had a reservation computer and I had a reservation computer. We set up a fictitious record, and in the annotations and the notes to that record we would type messages to each other. We did have PCs, I had computers and all of this, but we were using technology, and had actually from very back and early on, there had always been a lot of technology around, so there was always this kind of lurking sort of tech skill set going on in the background. But fast forward a little bit, and this is contemporaneous essentially, or a little before the kind of start of the web, an interest in technology, and for lawyers, including Larry, who is a mutual friend, an interest in how do we avoid regulation, how do we avoid censorship, how do we avoid a lot of the things that people have been talking about today in terms of incursions into our civil liberties that technology makes possible. Coming from this other angle, this European angle and interest and this historical angle, I early on developed a fascination with how do we actually use technology proactively to do things to make our democracy stronger, to make our society healthier, to make it better. Around about this time, I started a software company with a political philosopher. That is, never do that. I bet you do not have any startups with political philosophers.
Yet?
Yeah, don't do that. Not a good investment. We were interested in how we could use the web to foster more healthy democratic deliberation, so we started a software company called Unchat. And as part of that, I sat with and was educated by the geeks and technologists. We sat with each other in the world in which lawyers sat in offices behind closed doors. Geeks sat in open office spaces, as we're also familiar with now. And I developed a high level of technical literacy, or actually a mediocre level of technical literacy that was very high for a lawyer. In thinking about these questions, that's burgeoned for me into a career path that has taken me, I have been in private practice, I have been in the government, I have been in academia for many years, and now I'm running a thing called the Governance Lab at NYU, where we are both a think tank and a do tank, focusing on these questions of how to use new technology to help us govern better. So it has been one very long trajectory from the cafe houses of Vienna to Brooklyn.
So,
Perfect. Please.
my background is also, I have a degree in political sciences as well. I ended up starting to work for Al Gore in 1997, and up until his campaign, where I was his IT director. I did not invent the internet with him, although I helped him to name it. So it was a Saturday night with too many Miller Lights, and that's what came out. But as I worked as his IT director, which to me is a very interesting thing to think about retrospectively. The challenges that I faced in 2000 are really aren't even challenges anymore. It's I think quite astonishing the distance that we've traveled since then, which I'm happy to talk about. When after we lost, I ended up shirtless in my apartment, wallowing in misery. And
we all.
Yeah, we always end up shirtless, I guess. I also, for some reason, ended up eating a lot of Egg McMuffins for a period of time, but it's unrelated to my shirtlessness, but that's, yeah, exactly. I guess it's one of the signs of depression is your Egg McMuffin consumption. And for me, law school was plan B. So law school was a second career, and I went to law school. I started in 2001, and when I graduated, I wanted to be a lawyer. I wanted to litigate, and I went to a large New York law firm as a litigator. And the one thing I knew about discovery and the one thing I knew about technology is that I had no desire and no interest to do any document review. Right now, I run our document review it's at a different firm, so you can tell how successful I was at in that regard. But as I was practicing, I was junior, but I was probably older in years than most of my peers, and I recognized that as a first or second year associate, I'm not going to be taking depositions. I'm not going to be appearing in court. How can I, though, get to a point where I will be that person? And for me, it became apparent that the facts are at the basis of what litigators do, and unfortunately, the facts are contained in the document. So if I was a better document reviewer, I would have that much more opportunity. And I would participate in calls about what had then become eDiscovery. Before it was just Discovery, but for some reason they decided to throw an E on it. And I was on calls, and the partners would hang up the phone. It was about technology, and one would look at the other and say, I have no idea what they were just talking about. And I said, I got it. And they said, how do you know? You're a first year, you know nothing. And in retrospect, it was clear that they had brought me in just to throw me a bone, and they're not going to charge for my time and all of these other things. And I said, because I did this. I know what a PST is. I know what a DOC is. I know what all of these things are. It's not, and they said, great, it's yours, take it. And one thing led to another, and I became more and more expert in eDiscovery and ways to improve document review. And after a number of sort of transitions to different firms, I'm now at a different large law firm, and I run our eDiscovery efforts, our eDiscovery strategy. How can we use technology better to improve efficiency, to focus on value for our clients, and enable us as lawyers to get at what we really ought to be getting at, and what do we value, and how do we target and get there. So that was my path.
Do you keep a caseload?
No. So I'm a lawyer. I'm on the administrative side of the law firm. I haven't billed an hour in almost 7 years, which is terrific. Yeah.
Okay. Well, I'm the least interesting person. Sorry, least interesting person at the table. The one with the weakest bio, but probably the most accidental technologist at the table here. I'm actually not really a technologist. I play one on TV. My life started as a choice between library school and law school. I'm a third-generation lawyer, so my dad said, well, a JD probably won't hurt you. So I ended up going to law school. He said, you can always go to library school. So I went to law school and actually found that I thought I wanted to do that. I thought I could be a pretty decent litigator. But while I was in law school, I worked as a pretrial release officer in the lockup. So I typically worked the 7 at night till 3 in the morning shift. And got to know a lot about actually the information systems that the jail used to manage the prisoners within the lockup and within the jail system. So then I got an internship in the prosecutor's office. And this was step one in becoming a technologist. So we're being given a tour of the prosecutor's office, and one of the deputies said, oh, there's one of those things. This was a dumb terminal, right? So, and what I found out later is we had an AMDAL, which was really rogue for that point in time. Since most everybody had IBM, apparently someone had gotten very upset with IBM. Anyway, there was this dumb terminal. And she said, I wish you could tell me if one of my defendants was in jail. And I said, well, it can. And she said, well, how? And so I sat down, and I did the magic key thing. And I said, what's his name? And she told me the name, and I said, yeah, he's in 4C, or wherever he was located. And she said, how did you do that? And I said, well, there's this little thing. You just type in this, and you do that. So then the next thing that happened was my first assignment was to the chief trial deputy, and he had a big capital case. And we had about 7 or 8 banker's boxes worth of material to go through. And before, while I was working there, they had secretaries, but it was like a 10-to-1 ratio, and I was the lowest person on the totem pole, never going to see a secretary, but as a practical matter, I could type better than most of the secretaries anyway. And so they had a mainframe word processing program. It was much like HTML. You had to embed the code to make a paragraph or to make a bold or whatever. But what most people didn't understand was it also had an indexing program as part of it. And so I took the materials from the banker's boxes and I put them into a document, and then I indexed them a couple different ways. And then Monday morning showed up with the list. And suddenly, the next thing I know, I'm sitting on panels and things for the prosecutor as the computer guy, because I had discovered this wonderful thing that could be done with all these computers. And so at that point, the guy I worked for, Steve Goldsmith, who actually, some of you might know that name, he was deputy mayor here for a period of time. He was my first boss. He was very interested in building one of the first combined civil criminal justice systems in the United States. And at that point, we had hired Coopers and Lybrand to come in, and this is how long ago that was, to come in and build something. And after about $1 million, they had vaporware. So I was made director of the agency that then oversaw the implementation of that first system. So all this time I'm still actually during that time I transitioned from deputy prosecutor to head of pretrial services to court administrator. So I basically was everything within the criminal justice system except a probation officer. Because we were allowed to sit as judges in Indiana, so I did that half the time. So I had a really interesting opportunity to begin to understand sort of the basics of what it takes to build a large information system. And when the guy from Coopers and Lybrand showed me a data flow diagram, I thought I had like died and gone to heaven, because I really realized that all the stuff I kind of liked about library stuff was really very much information science and information processing, basically. So from there, I had a number of different stops and starts as trying to be a lawyer. I worked on the East Coast for a while in Philadelphia for Pepper Hamilton Sheets, and then went to Illinois and worked for a 6-person firm, did estate planning, general litigation. And then I finally ended up, well, in '95, I decided, okay, I've run away from being a lawyer. I'm going to give it 5 years, and if I really don't like it, then I'm going to library school. So that was roughly February of '95, and by May, I was going to library school because I just wasn't going to do that. But I still needed to work a little while to get myself sort of in order to go back to school. And so the last thing I did actually was I had a solo practice doing ad valorem taxation, property tax work in the state of Illinois. And sadly, I was smart enough to recognize that assessors' records were all public information, but not smart enough to make Zillow before Zillow got made. So I've always thought about those kind of information things. Then after library school, I went to work in the private sector for a consulting firm that did intellectual property stuff. And now I've ended up in the academy. And I'm in the academy because we were eventually bought by Charles River Associates, a Boston-based firm that's publicly traded. And there's a day, and I'd have you bring up Google Finance. I could show you this day in 2008 when our company lost 50% of its market cap. And that was the day I decided I probably should go back to school. So I decided to go become an academic law librarian. So I went to the University of Illinois. I'm on the hunt to be actually the director of a law library in an academic situation. But right now, I'm at the University of Missouri, Kansas City with Professor Lapino, where I'm the associate law library director, but I'm also director of IT for the law school, which gives me a really interesting opportunity to do a couple of things. One, to rethink and reinvent, I hope, on some level, what law librarians are doing now in this particular time in the academy. But second, to also stake out a kind of a claim for the kinds of things that I think we need to be teaching our students in order for them to become technologists. As I was telling my fellow panel members here earlier, technology is really a skill set. You know, legal, and the reason I'm saying claiming law librarians as being the natural sort of folks to do this is because if you look at what's happening in legal research, the legal research platform, so Westlaw, Lexis, Bloomberg Law, none of these things are standalone products anymore. In fact, Thomson Reuters has explicitly said they are out of the content business. They're about building legal solutions. They are building practice platforms. They are combining all their tools in a way that these are things that you have to understand how to use in order to practice effectively. So it's not just a matter of also, it's a matter of knowing technology, but it's a matter of knowing how this technology works. And as I was telling these folks earlier, you know, sort of following the Casey Flaherty Kia model, which you may have heard of, Casey Flaherty's general counsel for Kia, and he won't hire a firm without them taking a technology test to prove that they can use their material, or they can use Word, for example, efficiently, which is actually pretty low tech. But on the other hand, it's an example of what we could be teaching and should be teaching in a much broader and I think more effective way. So anyway, that's my spiel. Sorry, not nearly as interesting as those guys. But the end of it is I get to say everything I learned in jail, which doesn't sound exactly right.
Cute. Perfect. And so what we just did is like an unconference, but it's an unpanel. So we all just basically bubbled up the topics for the panel. And what I got from this basically was, Michael, you're talking about the need to teach in the academy here in law school. The information science is the phrase you use, skill sets necessary for people to practice law, right, of the future, and also to transition from a Bleak house to Geek house. I heard you talk a lot, Steve, about the practice of law and litigation and the transformation with discovery. So that's a data science, frankly, and you raised the question, what do we need to be learning in law school to practice that data science for that practice area? And for you, Beth, I heard for those that are practicing law or ascending beyond the law and working in government, how to use technology to govern better. And there's a direct, unbroken chain there from the other panelists. And then finally, first and last, Andrew talked about how to, what I got from it, it's still unvalidated by you, but what I got from it was how to, in effect, transform from lawyer to technologist or lawyer to geek. How to do it. Like, here's what you do. That to me sounds like a good panel. Let's do it. Discuss. And can we start with you, Andrew? Like, how do you do it? How do you, in fact, make the leap?
Well, so I said this sort of glibly earlier, but I would echo, what Michael said in maybe a somewhat different way, which is to say, then it's not really an echo, is it? I would echo it. I would recast it. That a lot of what you learn in law school is kind of like what books to look in to find stuff. At least I felt like that was a big part of my law school education. It's like, you want to find a statute, here's how you find a statute. You want to find case law interpreting that statute, here's how you find that. You want to find articles criticizing these cases or presenting an alternative view, here's how you find. A lot of it is just sort of like finding the right stuff at the right moment. And that kind of like systemic approach to the law as a body of information that needs to be navigated and cohered and so forth is it's really not all that different from what I spend my time doing now when we build stuff. So when we build a new thing at Betaworks, it's basically like, all right, you're going to have some profile information over here, some RSS feeds coming in over there. You're going to structure it in the following way. A lot of it is just basically like broad scale information structures, and then presentation and navigation. Okay, so that's the good news. The good news is that there's like common threads through all these things that unite it. The bad news, though, is that if you want to get out of the track of being a lawyer, and in fact, if you even want to get yourself into a position where you can be a sort of a first-rate general counsel at a startup or a technology company or something like that, you really are well advised to spend some time, spend some of your weekends, evenings, free time, whenever you have to do it, actually learning how to build stuff. Like your job gets a ton better if you understand the stack and the technologies that comprise the stack, and you understand how to second guess and assess what you're looking at. Is it good? Is it bad? Is it likely to work or not? should be done in a different way. Like, all of those are the kinds of questions that any lawyer at a startup will spend their time doing. It's not just a matter of figuring out the next round of financing, lining up your D&O insurance, all these kind of like corporate lawyer responsibilities. A good general counsel is, constantly assessing how to help get the company where it needs to go, and how to get the product to kind of live and thrive in the environment that we live in. A lot of that has to do with, kind of the structure of the market, the nature of the technology itself, and what stands between the two. So yeah, I mean, what I advise people to do, all the time is, take a class in building, a mobile app, let's say, or basic website architecture and design, and learn how to code. There's so many great courses and tools out there online, and it's so much less difficult than you think it is to go from a command line to, a fully functional, like interactive game or web page or something like that. It really is not that hard. You can do it in a couple of weeks, a few hours, a weekend. And you should. It's a little bit like learning how to fix a car if you're a driver. Like, you feel better about yourself, and you're more empowered, and you feel less likely to be snowed out in the world of, let's say, New York City startups, if you actually can talk the talk.
So I'm just thinking, as you're talking, I'm just thinking a little bit about, one of the things that's been on people's mind a lot, which is the healthcare.gov fiasco, one in which, the people at the forefront leading an effort like that are all trained as lawyers, and they're all trained in a particular kind of way of doing business, right? So they know about going to the Hill and negotiating for a piece of legislation. They know about the sociology of legal practice. They're really great masters in it. And to them, technology is an afterthought. It's a way to get, done after the fact, but all the investment, all the energy is in that wrangling about drafting the bill. And of course, the realization that has been brought home by this, by what happened earlier this year and late in the previous year, is that technology can't be treated as an afterthought, because otherwise you become, you fail to even have technology at the table, you fail to be thinking about how to implement the thing that you've legislated, and you're not in a position to push back against the technologists who say it needs to be X, if you think that's not your job to know what that is. So the riffing, I wholeheartedly agree with Andrew, and I think that law school, when taken as a given today, we tend to either see it or be so focused on memorizing the stuff that, you open up the head, you pour in a bunch of content, we're supposed to learn a bunch of seminal cases, memorize a bunch of, Penoyer, Renef, whatever, and everything that comes from it. It's either that, or it's about that mastery of the sociology of a certain set of institutions. How do I navigate the legislative process? How do I navigate the regulatory process? How do I navigate the judicial process? It's about learning how to be a member of the club. When what law school is about, what being a lawyer is fundamentally about, is about being a problem solver. And in the 21st century, problem solvers have to have an expanded set of tools in their toolkit, of which technology is obviously one. So if you are a lawyer, I don't think it's about transitioning from being a lawyer to being something else. I think to be a good lawyer, you have to know something about technology, because otherwise you can't have the conversation about healthcare.gov if you think it's only your job to know about how to draft the legislation. Unless you realize that what you're trying to do is to solve a problem, namely to reduce the healthcare cost curve and deliver better services to people, you've got to understand the full range you have to understand the situation and be able to manipulate all of these processes, the drafting of legislation, the crafting of regulations, the creating of a website, all become part of your bailiwick as a general problem solver and as part of the conversation. So I think it's not about fleeing from what we do, it's about a recasting of the recasting, allowing us to think differently about what is part of and what is included in that law school education.
I agree, and I think that to frame it as attorneys as problem solvers, I think is exactly right. And in order to understand how we solve problems, I always think about value, and I'll use an example. We have a client who is in a large litigation, a technology client, someone most people have heard of, and we were talking about collection, and their data is all over the place, and we had a conversation with them saying, you know, you're paying for this. This is going to cost you more money because of the way in which you store your data. And they said, listen, we're not in the business of defending lawsuits. We're in the business of inventing stuff. And those guys and gals over there invent stuff. And if they want to store their data that way, that's their prerogative, because they need to invent stuff. So the lawyers aren't going to tell them how to think. And because the problems we're solving have to be tied into what they value. And for technology, in the context of getting towards that end, we have certain things containing us. So, for example, in project management, there's this concept of the iron triangle, right? There's the cost of doing something, there's the speed of doing something, and there's a quality. And you can have something fast and good, but you can't have it cheap. You get to choose two, right? You can have high quality, low cost, but then it impacts speed. So that's iron triangle. There's another thing in the military, this concept of a force multiplier. And that talks about that a certain number of soldiers can do X amount of work, but a force multiplier is going to enhance them. So 10 soldiers and a helicopter is better than just 10 soldiers. The helicopter is a force multiplier. 10 soldiers and a drone, 10 soldiers and a tank. All of those things are force multipliers, right? And if we think about the iron triangle, that we can only have 2 of the 3 factors, to me, technology is a force multiplier. How can we, as attorneys, bring more value based upon these limitations, these constraints inherent in what we're doing? And using technology, particularly in the area of discovery, can enhance our value. They are our force multiplier for us, and it enables us to do more with less at a lower cost and higher value. And that, to me, is what technology enables attorneys to do.
And sort of following up with the academy and what the academy needs to do, I'm sure most of you in the room are familiar with Dan Katz and his Reinvent Law stuff. And Jonathan had asked earlier whether or not Dan had written this tongue-in-cheek article about the MIT School of Law. It's actually not tongue-in-cheek. That's one of his most serious presentations. Because the idea is that there's a whole set of things that someone would go to MIT to learn that they're not getting in law school, and that MIT would focus on. And I think that's right, but I think there's also this kind of large continuum, and the way I kind of frame it is with eDiscovery. So eDiscovery is this interesting point in the law right now where lots of law schools aren't teaching it, or not teaching it particularly well, trying to figure out how to teach it. Lawyers are struggling with it, judges are struggling with it, but what they're struggling with is really a continuum. So on this end of it, you have, what is autonomy? How does autonomy work? What is the technology to get the thing? And on this end, it's how do I craft the right order to get in front of the judge so I can get this part of what I need done? Well, this end can be taught in and of itself and can be a thing unto itself, but honestly, it's the whole spectrum, and they all have to be brought together in a way that the competent lawyer, the comment 8, 1.1, rule 1.1, comment 8 competent lawyer gets that spectrum. They don't necessarily have to understand the guts of autonomy or how it works, but they need to at least understand what precision and recall is. Because actually the truth of the matter is they're doing it when they use Westlaw and Lexis or Bloomberg, they just don't know they're doing it. So I just think the Academy has a really long way to go at the moment, but it's even more than that. The conference, Professor Lapino and I were at a conference yesterday for solo and small firm incubators and residency programs, sort of post-law school things. But there was a talk about the longitudinal law school, the idea that you begin to look for people in the admissions process to bring into the law school so that you seed them, or you have people who are seeded before they even get to law school. So in this case, it was people who were committed to the idea of social justice and public interest. In this other case, it would be STEM students. We need to do more for recruiting science folks. People who are technology, engineering, math, to come into law school. The Bill Henderson model The model that he talks about is, having folks who become domain experts, so that you become more versatile that way. You can end up working for an e-discovery vendor or someone, or you now have the skill set to be able to advise clients appropriately. But the academy has to be in a position to be able to teach those things in an effective way.
So, excellent. So now that we've had that panel, let's try something different. So why not apply the insights that we just heard and spoke to a problem? One of the things we brainstormed getting ready for the panel was some example scenarios of that come up in everyone's practice, whether you're CTO, lawyer, or otherwise, and talk through how people might approach that. So the top three, I think the most appropriate one is there's a high priority launch of a web service, because since you brought up Obamacare, you called this one to my attention, but also it's a nice scenario. It happens all the time. That web service could be a government agency, it could be a private company, it could be something internal to employees, but it's high priority and you're launching a web service. There's technology involved. There are legal implications frequently depending on what that service is, if it's heavily regulated in some way, for example, or if it's part of a supply chain contract with complex provisions that must be modeled. So generally, I'm curious, well, I can say just one word, because people have referenced MIT like multiple times, Jonathan and others. Something we do a lot there, and the reason one of the key reasons I was drawn to it is we so-called hack things. We hack them up, and by that I don't mean unauthorized access to a system. I mean agile, rapid prototyping design method that favors not having things perfect prior to start, but rather an iterative approach. So hackathons are well exemplified, or putting something together that's rough as a rapid prototype is a good example of that technique, and that goes across really almost all the departments. It's interesting to see how it plays out in the human studies as well as the hard sciences. I don't know what you're thinking the right way to do this is, but can you speak a little bit to a scenario? And I know you've been through this many times. It's really your career. It's a high priority launch of something on the web, an app, a service, a site. How would you exemplify what you just described, Andrew? Like, so you've got people that are either learning or they're showing it.
So the typical, the typical. I mean, there are a couple of axes of tension that arise in these scenarios. One that you often see, it's particularly true in government, it's, maybe less so in startup land, but is, the lawyers basically just act as like a Maginot line of defense against launch. They're just armed and ready and isolating risk after risk after risk and all of the things that are going to go wrong and trying to document everything. And that was, it was fascinating to see the healthcare.gov sort of debacle from afar because, Beth and I are probably two of the least surprised people on the planet when the whole thing melted down because the government is sort of like purged itself of technical competence over the years. It is, outsourced to contractors, kind of the provision of every form of technical service, and part of that is because government can't pay very well, technical skills are very much in demand, and virtually anybody of any level of competence in the government can go flip over to being a contractor and make twice the money, and so they do. So that's part of the problem. The civil service structure makes it very difficult to feel like you're going to have a flexible and interesting career as a technologist inside government, with a few exceptions. There's some agencies like NASA or the NSA, which, if you're into that kind of thing, have spectacular vistas for professional growth. But anyway, for most government agencies, it's just not there. And so, so anyway, what you end up with is this kind of like lawyer-administered, lawyer-driven contractor world where it's all driven by the things that can go wrong. The interesting thing about healthcare.gov was that it had a deadline by which it had to go live, unusually, because usually these things just kind of like stretch on for decades. But you saw what happened, which is that it launched totally pre-baked and riddled with bugs, errors, and terrible architecture. So anyway, so one thing that goes on all the time is that, and a good CTO lawyer or lawyer CTO is somebody who understands how to orient the legal thinking around what Beth said, which is problem solving rather than risk flagging. Most lawyers think their job is control risk, control risk, control risks, and use instruments like contracts and indemnities and exchanges of letters and all sorts of other things to minimize risk, to identify it, to call it out, and then to smother it. But that is totally wrong in the technology world. You cannot be that lawyer. And I have to say, when I was at Google, I saw what I think is probably the best legal department of any technology firm ever. Incredibly deep talent, extraordinarily competent lawyers, from very junior lawyers to senior lawyers, up and down the stack. And the ethos there was basically like, nobody can ever say no to anything. You know, like Larry Page says that we're going to like build a nuclear reactor, you know, under the Google office in New York. Your job is not to say that's insane. Well, maybe you can say that's insane, but like, okay, let's go do it. That's your job. And, you know, sometimes that gets a company like Google into trouble, but the ethos was solve the problem. And generally they'll figure out that it's a ridiculously terrible idea on their own from the engineering perspective. But so anyway, that's like one part of the lawyer's role in the process.
Google Nest today.
Yeah.
Google Nest
Could we have a microphone?
beautifully. Oh, the show.
Hey.
Google Nest was Google Nest was working beautifully, and no users were having any reported issues, and they're withdrawing Nest Protect smoke alarm because there may be a possibility, if a set of events were to occur, that the smoke alarm would turn itself off. And so Google Nest is being pulled, which I think is
Did not know.
shocking.
Okay.
You were there pre-IPO?
There you go.
I was, yeah.
Yeah.
Yeah. Do you mind to change it as a publicly traded company? You're saying it might be.
And actually the question I asked was, let's talk about examples of times when it's working so that we can get our minds around what is this new model of when lawyers act in a way that's conversant with the technology sufficiently so that they could be posed a question, how to, not why not. How do we engineer? How do we design? How do we creatively charrette a solution that operates at the business, legal, and technical dimensions elegantly?
Well, just to add one other thought, I'm sorry I'm like blathering on so much, but one other thought, which is that the area in consumer internet services and enterprise internet services where this comes up all the time and where the lawyers have the most important role and where they can screw things up the most or help out is around privacy. So privacy is the management of information. It's fundamentally about sort of doing right by your users, and secondarily, it's about legal liability. And so lawyers interact with technologists around privacy issues probably more than anything else, and set the parameters for what kind of data can you carry, what do you have to tell your users, what kind of consent do you have to get. And this is one of those areas, like just to be very specific, where the lawyer can either like solve the problem and figure it out and set real parameters, I mean set boundary conditions within which the engineers have to operate, or they can basically like blow up, you know, your ability to actually launch the service. And a good privacy lawyer is one that is very much a problem solver, a principled problem solver, you know, a user-focused problem solver, but a problem solver.
Principal problem solver. Tweet at the ready. Beth, how do we do this? So you got a new launch. I know you've been through this too. When you were CTO, you did a lot of open gov, and since then you've done launches in your foundation now. When it's hitting right and the lawyers and the technologists and frankly the business team are operating well together, what does it look like?
Well, as is being hinted at by everybody explicitly, is that first of all, it's about having the lawyers and technologists there from the get-go as part of the design team for any launch. And you know, whether the lawyer and the technologist are one and the same or are two different people will depend on the people and the organization, et cetera. But I think, you know, when it's done well and when it's done right, I mean, the lawyers, you know, they're part of the same team. If you're starting from that common point of saying our goal is to get this done, whereas in government, what we've seen far too often is that, as a friend of mine refers to them, government is the land of the no machines. And it's your equivalent of the Maginot Line, which is a better phraseology, but the lawyers are often there just to say no. to serve as the babysitters, to serve as, and it's with great conviction that people will tell you, I've been in rooms where people will say, I am here to, babysit the politicians. I'm here to babysit, in other words, either the technologists or more dangerous are the politicians, the people who want to do crazy stuff, and they're there to safeguard the public interest, the taxpayer dollar, etc., by doing things exactly the way that we've always done them. So the notion that doing something that might be perceived in some way as different and therefore experimental is a bad thing, I think is changing. I think is going to change, because when you've had people who work in government, like an Andrew McLaughlin, and people recognize the value, the people that worked around him and with him recognize the value of that, it creates a demand for this new generation, this new type of lawyer who is the yes machine rather than the no machine, and who is the person who can be at the table as part of the conversation about how to have the web service launch. I'm just thinking about I just want to cite this example since you want a specific, and it's not a project that I've designed or built, but one that I've admired from the side, is work done by the Annie E. Casey Foundation in Indiana, in fact, as well as in their regional child service offices that they operate. Their goal is to use technology to help improve the plight of abused and neglected children. And what they've done is they've come in and take the very hard task of trying to re-engineer a creaky old antiquated legacy systems that are used in child welfare offices around the country. And starting with a pilot they're doing in Indiana, what they're essentially doing is rolling out what they call Casebook, sort of like Facebook, for children, and essentially you put the child at the center, and all the different providers and social workers and doctors interact with one page. So it's an information management system so that information doesn't get lost, doesn't fall through the cracks, and so that there's a hopefully better conversation. They're seeing tremendous results already in the first year. But it's a project where they sit in an open space with technologists, with lawyers, with domain experts who work on child safety and child care and child services, in a team together working on developing a solution that is radical and revolutionary on the one hand, but at the same time interfaces with, that works with, that connects to traditional institutions and cultures, so that the state of Indiana can say, we will adopt the system and we'll try it and we'll do it. So I think the temptation to say, let's throw the law overboard and just go the kind of libertarian, geek, Silicon Valley route is very tempting to say we can do everything with a startup. But in fact, institutions have an important role to play, governing institutions have a strong role to play, or other kinds of institutions. And so we need to be able to reconnect those legacy systems, whether they're technological or policy and legal, to the new way of doing things. And for that, you need people who know what Panoy or VNF is.
They must be in the broader Project Penumbra. Okay, you're on.
So I think what we have to do as attorneys is, again, understand the business that we're working for. So if we're a GC, we have to understand what our employer is in the business of doing, and enhancing that and helping to support it and not create all of these roadblocks. I think this conversation about Nest is interesting. I haven't heard it before, and I don't know anything about it, but based on what you said, if they stop selling Nest because it might not work when there's a fire, think about GM and what they're going through now. So as the attorney, we have to sit down with them and discuss their business. You're in the business of selling these Nest products. You're in the business of selling these cars. If we don't fix this issue, what's going to happen? And let's help you solve this problem. This is your exposure. This is your risk. This is the cost. You're in the business of doing this thing. Are we preventing you as the attorney from doing the thing that we're in the business of? Or are we being your early warning sign saying, I know you're in the business of selling these cars, but this is to the point, like, people apparently are dying, and the cost might or might not outweigh the cost of fixing it, might or might not outweigh the cost of not fixing it, but there's a larger exposure here. So we're not trying to prevent you from making cars, but we do have to talk about this issue here. So if there were 12 houses that burned down and the smoke detectors never went off because of Nest, then they're in the exact same position as GM was. And the question that the head of Google is going to ask is, well, why the heck didn't you recall it? Why didn't you fix it? And what we have to do as the attorneys is help the business people make the business decisions. And we have to give them that advice and counsel to facilitate those decisions. And sometimes even with the best of intentions, people will make bad decisions. So perhaps GM said, you know what, there is this problem, it definitely exists, but it costs $100 million to fix it, and if 10 people die, figure out we'll settle out at a total of 80 million, and 80 million is less than 100 million, and we're in the business of making money. We had that panel earlier about the corporate responsibility to shareholders, and maybe that's the way that calculus is done.
Good. So our final panelist is Michael has kindly deferred some time to stimulate what we've been saying with even a more direct example. So you all won't be able to see it here in the panel, but tell me if this is an example of what you have in mind, or if it isn't, and and why. So this is a project I'd done. First of all, I happen to agree with all the panelists, and here's an example of a way I had attempted to do what you're saying. This was a project that was in a so-called identity federation. It's basically single sign-on, using SAML 2 in that case for the insurance industry. And what I realized is that there's mostly technology. There's a lot of legal issues here. This is brokers, agents logging into everything from Progressive Insurance to the Hartford and many different industry large carriers to do health, life insurance, auto insurance, many different types, and a tangled web of many different systems, many different passwords. They can unify it with technology. Yeah, they can, but it's somewhat complex to integrate all the systems, to make sure all those contracts reflect that we know who has the risk. And the major thing, of course, that I want to reflect that Steve's been saying again and again is the business case, the business drivers, the business owners of the system. It starts and ends with them. So the way I reflected in this project was they hired me to basically create the rule set and, in a sense, the architecture. My title was architect in that case, and the title was business, legal, technical architect. So what I did was convened across the industry, send your business people, number one, to make sure we understand what we're doing and why, the scope. And so the big and the small players and players from across the industry sent CEO, or more often COO or CFO, or people that work near them to represent them at the meeting, to describe and agree on what is the purpose of this, what is the business driver, what's the business here, what are the imperatives and the priorities. Because lawyers we shouldn't tell them that, technologists should not tell the business people that. We have to hear that and then iterate. Then there's a second committee, send me your lawyers. And by having the larger and smaller firms and some firms from across the industry types, broker agents as well as carriers, send the lawyers, enough of them in my judgment, to get traction on what their issues were and to iterate those provisions of an integrated architecture, the roles and responsibilities, the relationships, how it fits with the existing contracts, when the risk of loss shifts, basic stuff, that we could come up with something that would have some traction. And then finally the technologists, which was the biggest committee, and that was the fun, in some ways the most interesting committee, and they came up with the architecture and it was very cool. The idea then was to by not having the lawyer be at the end of the process on a marginal line with arms locked, thou shalt not pass, rather smoke them out right in the beginning and have them come to the meetings. But you can't have the lawyers at the meetings because that's a culture clash. But there's a way to integrate them in so they can talk. And then basically in this case, I just literally cycled it. So when the meeting was done, we had a draft of a section, like section 1's business stuff, section 2's legal stuff, section 3's technical stuff, and then we'd circulate the draft to the other two committees, get feedback, and then people were ready to have a conversation. And then at the end of that process, we had a unified glossary. At the beginning of the process, we had chaos. Even within the teams, people use different words. Certainly between business, legal, and technical, there's different words talking past one another. By doing this type of process of coming up with different methods, and this is just one, I found it was possible to start to get at integrating better. And there were enough lawyers and enough technologists and enough business people that wanted to work together to solve an important industry-wide problem that it was a reasonable context for it. In smaller and smaller teams, you can't have committees. You don't want committees, but there's got to be some way for people to talk. So what you see here, this is the result, and we put under Creative Commons, God bless them. It starts with the scope, like what are we doing, and then it's just a bunch of business, legal, and technical terms. You can see it yourself. It's idfederation.org. So anyway, that is an example. Let me ask you, if there's a big launch for a project, and it requires an architecture, and let's say it's going to require some new terms and conditions for whoever you're dealing with, it may require some new technology, or at least a more explicit specification of the interfaces and maybe the standards or configurations. It'll require some business processes, some business statement. It require probably, at least some statement of why we're doing it. Who's the profit? What is the goal of the project? What have you? Is the business drivers there? Have you ever seen, how about this process of having an integrated architecture with some business, legal, and technical sections literally comprising one unified architecture to cause people to be in the same team but pulling the same direction? Discuss. Is that an example of what you're thinking? You're like, oh my God, not that. Like you missed it because. Or I have a better idea, and it's this.
I mean, I think it just makes logical sense, because depending upon what the business is, it gives the attorney the opportunity earlier on to address the problems. And there are certain problems that only attorneys can see. I mean, if I was starting some sort of gun making company, and I said, all right, instead of shipping the guns, we're just going to have people take them and fly them places, everyone's going to say, well, you're crazy, you can't take guns on a plane, right? And that's easy.
It's worse than snakes.
Right, yeah, it's worse than snakes on a plane. That's an easy issue to solve. That is a legal challenge, and if everyone thought it was a great idea, ultimately the lawyer is gonna kill it, right? There are other problems that only the lawyer can see. And if you just say, if you're sitting down at the kickoff meeting of the healthcare.gov thing, and the lawyer's there and say, by the way, everything needs to be encrypted, and then they sit back. Now, that's not doing anything other than saying, just so you know, there's this legal risk out there that's easily addressable up front if you think about it in this context. Yeah. And I think that's what you're sort of bubbling up is it's not as much of an issue if you can address it early on.
So Dazza, to me it sounds like you're exploding out the concept of what the legal hacker movement is supposed to be about. We do a weekend legal hackathon because we felt like wallflowers at the hackathon. Yeah. How do lawyers better integrate themselves and adopt that hacker spirit? Yeah. So we brought them to us so that we could sort of learn and actually play a pivotal role. But it sounds like you're taking a weekend-long enterprise and turning it into a bona fide venture, a process for real ventures outside the confines of a weekend hack.
Yeah, that would be where this would end up. I think this method, this method seems to work pretty well with humongous projects that go many months. This one went more than a year, and you have a long time to get people ready for it. Ultimately, if people, if the academy did a better job and people were ready to talk to one another, and we're ready to have an agile sprint session, you could do a lot of this very quickly indeed. And I think it's better done, most of it, quickly in like a hackathon. And actually, sometimes, we do a few things at MIT. We do computational social science studies. That's in the lab that I'm at, Sandy Pentland's lab. Very frequently, when we're getting ready to start one of those studies and we're architecting it, it's mostly technical. How do you get the data from the Android phones? How do we get them in the hands of the students or the participants? There's a legal part, it's informed consent, some sort of IRB, and there's a user term thing they click on. And it's mostly a business driver, like what is the research we're trying to do in this case, and how is it better? How do we get the right data sets? These people that work with Sandy are agile by birth, apparently, and we cover a ton of ground in like a few hangouts, but then what you want is a slow boil to iterate it, circulate it, socialize it with organizations, get feedback, and then come back and maybe do another sprint. So I think there's a role for these hackathons. It's invaluable as a model, but then it probably needs to serve as like punctuation of a project within a larger envelope that ensures that the right questions are asked and addressed. Some adult supervision, which is why I always like to start and end with the business people.
You missed the demos. We did a greatest hits of our post-hackathon activities. So a lot of the projects that were incubated at the hackathons demoed today, several months later.
Yeah, but my only like sort of wish is that enough of your students can get enough years of experience so that we can start hiring them, because what you're teaching is exactly the right stuff. I mean, it's an attitudinal thing as much as anything else. But I have great great hopes that as you build the center of gravity, or I have to quit using these screwy metaphors today. So you build like a growing blob of, legal hackers that will come to characterize.
They launched
the
Legal
profession.
Hackers Detroit this week. Legal Hackers DC ran an event a couple days ago. We had Seattle. Seattle's been tweeting all day.
Yeah.
I think now we're launching 16 chapters in Europe in the next few months. So
good.
I think
It's why I'm
happening.
here, actually. On a personal note, I wouldn't be here if it wasn't for, the Legal Hackers organization that was an outflow of your Bleak clinic and Phil Weiss, I think, who's an alumni here. And it really opened a great world, frankly. It's exactly the people we want to be working with at the Media Lab in our burgeoning legal science clinic, and it's taught us a fair amount too. We're going to host one of the New York Legal Hackers events in the Media Lab in June and make real progress on quite a few issues. It might be an area to maybe explore some of the ideas from you all on the panel about how to transition and what would be taught in order to transform government. And maybe some issues with predictive discovery or library and information science could be modeled in a more of a rapid, low pressure way where there isn't a project launch or a funder deadline of some sort, but we can literally be informal and try some stuff. These hackathons are fantastic, and for a legal hackathon concept, I thank you.
For me, the great homecoming was the Center for Constitutional Rights called me the other day and said they want to do a legal hackathon. That shows that it's penetrated the advocacy community as well. We have a couple questions. I don't want to take it away from you, Dazza.
I hereby authorize you to take away from me.
This is a great flow. Anyway.
Thank you. So one of the things that surprised me about your panel is I haven't heard any conversations whatsoever about how you use technology to serve as the client. And what's going on in corporate America today is the social business revolution, and I'm not talking about social responsibility, I'm talking about the use of social technologies for collaboration, communication, and the spread of knowledge. And I'm surprised that throughout the conference there's been no mention whatsoever of that. So I'm wondering from your perspective, what do you think of the ability to use social technologies to provide better customer service to your clients and workflow and transform the way people are working, both lawyers and on the business side?
I think that's a different conference, right? So I think that sounds really interesting, but I don't know, you want to talk about?
Lawyer as a CTO, that's what I'm seeing.
Well, I think that,
Lawyer CIO.
All right, we can talk about that if you want to.
Well, you've built some social media sites.
Well, all right, you want to, I'll tell you one thing that was interesting, just by way of anecdote, was that when I left Google and went into the White House around 2009, and then came out 2 years later, and by the end of 2011, I was working at Tumblr here in New York, right? So a very young company. And the way that the tech industry that I had experienced in Silicon Valley was doing work in 2009, and what I entered when I got to Tumblr was really different. I had to completely relearn how I work. Tumblr just worked in a very different way, which is now the way everything that I do works, right? So it's a whole different tool set. So where in our generation, I guess, email is the thing, right? So email, everything that happens is email. And I like email because I'm a pack rat, it's searchable. I have all my archives dumped into Gmail, and I can kind of find anything at all times. It's great, I'm a huge email fan. But literally nobody that I work with anymore uses email for anything other than hyper formal, communications. It's just nobody cares about such a clunky and asynchronous form of communication. And so instead, everything happens through this kind of slew of different tools, depending on the company and the culture and how you get things done. But it's everything from Asana for project management to HipChat for in-team, inter-team instant messaging, to my team actually talks to each other sometimes in Twitter. We just sort of talk in public about stuff. And anyway, it all gets it's totally weird and jarring for a little while, but works way better. And I feel like we get a ton more done more quickly. So for example, what is customer service? Well, it's like a website where you enter FAQs and you answer all of them in public and archive all of your responses, and you tweet back at people whenever they've got a problem, and that's how you do. Anyway, it's just very different. And so, what the nexus with being a lawyer is, I suppose, is that you have to overcome, at least up until you're publicly traded, and subject to Sarbanes-Oxley rules, but you have to overcome a kind of a natural lawyer's instinct to have tight control over all of the channels of communication, so that when discovery comes around, you've got your ability to put your hands around it. Like you said, with a client that just says, like, I'm not going to tell these people what to do. Maybe it makes discovery more costly, but we're just not going to. We work the same way. The short, by the way, like, important thing to note is that, like, for those of you that are going to be graduating from law school and going out into the working world, and you might think about doing your own thing, because of the availability of these tools and the application of Moore's Law to cloud computing and all that, it is staggeringly cheap to build the infrastructure for an enterprise these days. I mean, it is amazing to me how quickly we can stand up like a complete and robust set of systems in like an hour or two for like zero money, and get to work. It's amazing, and it's something that you should be, excited to take advantage of when you get the chance.
I think I would just say that the reason you don't hear more of it is because for us it's such a given that we're not even surfacing it. So we are people who work in an open and collaborative fashion. All of our work, at least all of my work, relates to how to be open and collaborative. We've been doing legal hackathons before it was called a legal hackathon for 15 years now, trying to do things like hack government agencies and hack corporations and turn them into more open ways of working. Adopting the principles of open innovation is sort of inherent to everything that we do. And it is, I'm glad that you surfaced it as a point, because it is sort of antithetical to the legal mindset and culture. And it is also very antithetical, I even find, with my students, for whom doing things like taking shared notes on a hackpad as a collaborative single set of notes, tweeting throughout the class, doing that sort of thing is still is even for students today, generationally younger, but the mindset of kind of the closed mindset is still so pervasive and strong that the notion and the argument that has become better known in business than it has in legal and other circles, that open and collaborative as a way of working actually generates more value and advances the ball and furthers innovation. And we have a whole set of rules that just don't sync with that anymore very well, and we're trying to navigate that. But I think you don't hear more of it just because we as a group probably take it so for granted that we tend to forget.
Most of group might do so, but most of
right.
legal America don't.
I mean, and I'm in
that in law school.
Right, you're teaching highlight. The law school teaches highlight in black. It doesn't teach collaboration.
And I'm on the exact opposite side. So I work in a large law firm. We have more than 1,000 lawyers. Until recently, it was all dark mahogany and leather-bound books. And it's much more challenging for us to change. And I think it's baked into the law firm model. It's baked into the succession within a law firm, the apprenticeship model of rising within that organization, and this thing called educated in capacity, the idea that the more expert you are in a certain way of doing something, the more blind you are to ways to improve doing that. And then we exist in this world where we're under increasing pressure on economics. How can we justify our rates? How can we justify our cost? And there's a growing importance for law firms like ours on efficient project management, matter management, legal project management, and there's a burgeoning industry of that. But the traction that the technologies have and the traction that our clients have in insisting that we adapt to these and accept the changing nature of the business is slow, and it's slow because, again, of the nature of the legal business, and I think there'll be certain people who are successful, and certain organizations will be successful, and certain organizations won't be successful. And I think the successful ones will be the ones who, to whatever extent they can, understand that the nature of things is changing, and
So
we have to.
Andrew, and then Michael.
It's striking that none of we work with outside counsel, on things. At Betaworks we do a fair number of private-to-private deals that need kind of like bespoke, legal documentation, and it's amazing like how weird it is to interact with them. Like they just are, it's like a
It's a throwback.
Yeah, in time warp,
Yes.
I just have to say, like, just anecdotally, like one of the things that's so jarring for a lawyer in kind of like a startup environment, where, as Beth said, like these like the walls are fully permeable and communications are flowing in and out in real time, is like the other day I was. Somebody on my team was like, "Hey, you got to check this out. It's this really funny, not safe for work thing I just found." And I was like, "You're at work. You realize you're at work, right?" They're like, "Yeah, but check it out. It's funny." You know, it's like, you're like, okay, I guess like the boundaries between home life and work and everybody like with their laptops out, doing, tweeting on the company account at 1 a.m. But it's just like it's completely incompatible with like a nice foursquare, linear, lawyerly, structuring of how a workplace is supposed to function for purposes of minimizing risk, if you view it that way. And instead, you're trying to kind of like maximize risk in order to push your company to take the biggest chances they can take, and smart chances, but to take like big chances. And it's just a completely different.
Michael, you actually know something that's critical here, and we talked about it before. You know a number of things, I'm sure, but like so very provocative concept here about, you could, with Puppet scripts and some other things, spin up an entire enterprise quickly. I think you said in an hour. I don't know, I could do it in a day, maybe, between the different systems that you'd need. And then if you look at, like the folks from the state of Kansas that had participated in your, one of your initial GovLab conferences, Beth, at the Secretary of State's office, they're really seriously taking on the proposition of fully automating corporate filing. Create a new corporation, amend the name, play it out, dissolve the corporation, all online, all digitally. I'm starting to see the contours of an interesting, the shape of things to come, when all the enterprise is truly a digital enterprise and we all are truly knowledge workers. Because of your library science and legal academy background, what you told me before, you said you have a sense of how to structure the data so it shows up as knowledge that is ingestible by business people, by technical people, and by legal people. How on earth do you do that so that we could even seed the enterprise systems that would be fresh and configured maybe on day one, but have no data in them? How do you express data for a truly digital enterprise that can live and die at the speed of light? How do you just express that data?
Right, and I'm not sure I have a complete answer to that. Part of what we talked about yesterday, or is in preparation for the panel, was this notion, of course, that the law is information intensive. I mean, that's the thing I've always thought about. And so that information intensity leads to a couple of different things, which is versus creating a different way to think about what are you seeing in front of you when you look at information. The second thing, frankly, though, is to be able to work collaboratively together. And so one of the things we've done at UMKC is we've installed the Tidebreak software, which is a collaborative software. So we actually have a large tech room where we've got 6 monitors on each side of the room, and then a big screen at the front. And what the software allows us to do is at the table, have 4 to 5 students wirelessly connect to a workspace and then work together collaboratively in it. And then begin to design knowledge objects, really, working together. And so then the instructor can bring them up to the front. But part of it is just this notion that you've got a different way to understand the information that's being presented and how to track it through. I mean, at the end of the day, it's about project management, it's about knowledge management, and that's the kind of thing a technology person, I think, brings to the table in terms of looking at information.
That was cool. Okay, we need that software immediately for the next panel so we can design knowledge objects, because I want to be on that team. We have, I think, one more question from our erstwhile videographer from of the internet, Jonathan.
Jolly, my name is.
Oh, Jolly, I'm sorry.
Yes.
Excuse me, Jolly.
So I heard you say at least a dozen times the word agile. I heard you say sprint about 3 or 4 times. I didn't hear you say scrum.
I was thinking it.
Or pigs and chickens. But I wonder how many of the law students here or lawyers know that you're talking about a defined software process. And I'm just wondering how much things like these, the established knowledge and experience of developing agile as a software process should perhaps be taught to law students and brought to legal law development.
Again, I think you're touching on a burgeoning industry, especially that's touching law firms like mine. Again, we're getting increasing pressure from our clients to lower our costs, and a necessary predicate for that is improved matter management. It touches on knowledge management. How can we leverage past experience for future experience? How can we not rewrite a brief? How can we not redraft the same contract? All of those things are tied to improving the efficiency of the services that we offer. Part of it is technology facilitated. I don't think it will be technology driven. It's not the nature of the practice. But the most, I think, significant stumbling block for us, and perhaps it's greater than a stumbling block, is just the nature of the people who choose, one, to practice law, two, choose to go to law firms like mine, and then three, are successful in these large law firms working on these large matters. Again, the nature of the pyramid of associateship to partnership, it's a pyramid, and there are people who opt in and there are people who opt out. Some of them are opted out. They don't choose to opt out, but they're opted out. But you figure X number start all together, and then X minus a significant number end up as a partner. And the success, the factors for success are tied into this apprenticeship model. They're following their predecessors, and that's why they're successful. So the opportunity to change is much more challenging. And then if you think before 2008, when the economy the economy had all these issues, the GCs were all former law firm people. So there wasn't the drive from the GCs to be more efficient, because they came from where we were.
So good. We need to be wrapping now, but very good. That was basic context to the question on the proficiency and understanding of this agile method and how it plays in the broader context and the bigger trends. And so why don't we continue wrapping this direction, and Beth and Andrew, last words, if any.
I would just
final thoughts.
So just the final thought is, what's going through my head is so the way that I teach and work with my students now is very much adopts the agile and design methodologies. And one of the things that they often talk about is how different it is, and I'm sure Jonathan feels the same way, from the rest of their education, because it starts, it goes back to the beginning. We try again. We're very agile in the way that we approach things. That is completely different from a law school class in which you sit from beginning to end, you take one exam at the end, and then you get some feedback in the form of a grade. The essence of that method that we begin in the first semester of law school runs counter to everything that designers and hackers and technologists use in the way that they work and the way that they solve problems. So I think until we kind of until we change that core building block of that, and which is tied into a whole set of other economic processes, et cetera, I'm going to sit here passively and receive some content. At the end, I'm going to take an exam in which I parrot something back. Until more of legal education, until sort of Jonathan's class doesn't become the required first-year curriculum instead of the capstone of the third year, because that is what real life looks like. It's about starting and stopping and doing over and fixing again and hacking and redoing and fixing it on shorter deadlines. Which is why, as you were talking about architecture before, I was thinking what a lawyer hears by that is I have to architect every possible permutation till the end of time before we do something, whereas you mean something very different. I think we mean something very different, which is we're going to do things in an agile way. We're going to do things quickly. We're going to see what works. We're going to learn from it. We're going to try to do things again. Till we adopt that experimental mindset in our institutions and in the academy, we have a lot of work to do. We'll be having this panel again next year.
Yeah, Beth, from your lips to our dean's ear. Do you have a little more?
You don't want to teach the whole first year class.
Would you like to say anything else?
Mind a little bit.
No. So if I may, and just by way of a closing wrap, say, we had a chance to have a sidebar, and Jonathan and I, a few moments ago, and agreed that at some unspecified date, which we haven't set yet, but now we'll set with coordination for the program here and with Jonathan, we will have our next legal hackathon at MIT using your system, NY Legal Hackers. And one of the panels, which I'd been thinking about doing before, but I just decided we're definitely not a panel, I'm sorry, one of the projects, an agile project of the type Beth just implored us to adopt, basically, in legal education and law practice, is I call it CorpBot. or basically, we got corp dot everything, and it'll be basically, let's make a let's stand up an enterprise from nothing and design its systems, and there's legal aspect, business aspect, technical aspect.
Who gets the credit?
And then maybe we could concoct it in a way so that it's dealing with government in some way. So Andrew has kindly agreed to talk later about some of his concepts about how to do that, but I'd be interested to learn more about how you would spin up literally a corporation in an hour or two, and maybe we might adopt some of those methods. Maybe some of you have ideas, but the challenge is we now have a forum. We have agreed between the Media Lab and your institution, in the form of your agents, me and Jonathan, to have a forum. It's the next legal hackathon, and I challenge you here in the room and you out there in cyberspace, you, to come and participate. And you can do it online and on Hangout and literally invent the future. Now, I don't even think we're at reinventing it now, and why don't we attempt to apply and figure out how to apply these agile methods to the practice of law and result in a corporation, and maybe let it live for a little while. Who knows, maybe we can dissolve it by the end of the, after a good life at the end of the weekend. But anyway, that is the challenge. We have a few other projects going as well, which we can think through, but so it has been born, and let us play these ideas out and use it as the parameters of some of the things we'll test, because they were great ideas from every one of our panelists. You guys really fulfilled, I think, a tall order that Jonathan put before us with the title and with the theme of the conference. And I have to say, it was not just an honor, but it was a lot of fun, and really I learned a lot and took a lot of notes from being able to help facilitate your dialogue. And thanks for the opportunity, and why don't we all thank them right now. And back to you.
So I offered the convocation, now I'm supposed to do the benediction. And a fitting place that you had a sidebar, so speaking of bars, I think that Jonathan and Paul should find an establishment that's appropriate and invite those of you, including our many students. I'm glad to see Jedediah and Jared, our winner yesterday of the Shark Tank competition, Francis, so many others of you here, and find an appropriate place to have a round or two on me. Send me the bill, I'll take care of it. And I think that would be an appropriate way to celebrate and further stimulate the fertility of this conversation and keep it going. I would have been with you more had I not been so busy today chopping law school prices. My arm is really sore. Some of you may have noticed. Now, it's not just that I like to say that we're way out front, and online you may have seen the New York Times has a marvelous article, James Stewart, I'd suggest you look it up about that. Now, the reason that this ties into what we're talking about here is, first of all, at this law school we're taking a very modern, entrepreneurial, if you will, approach to things. I don't believe that the business model of law school makes much sense. Law schools around the country feel pressured to do less and charge more. To me, that just basically is wrong. So what we're doing, we're taking a different approach. We're doing more and charging less. And I think that actually will be an irresistible model. But we'll see. Who knows? Sometimes when everybody else is not doing something, there's a reason. But we're going to see it. Now, the reason this directly relates is the true motivation for this is that it's an access to justice issue. It's an access to affordable education issue. And there's so many people who have an absolute desire to attend law school, and including this law school, and for this very special offerings, including a cube, but they can't afford to do so, and so their ability, their motivation is there. And we're not talking about below the poverty line people. We're talking about people from all different kinds of background. They're just afraid to take on the high cost. And then if they do come to law school, they graduate with such debt that this is where it really fits, is that they are not able to pursue jobs and careers and opportunities that fit their passion, their talent, their preparation. They feel constrained to search for jobs, sometimes unsuccessfully, that can pay off the enormous, excruciating debt load. So we want people to be free if public service is what they want to do, but the jobs may not be as high pay, or if the financial arrangements are such that you're not getting a steady paycheck at the beginning. In other words, working in an entrepreneurial operation, the type of work that many of the CUBE clients are engaged in. We want people to be free to do those kinds of activities. And so, in fact, the business model and the tuition cut that we've announced today as part of an overall package we have to start to make law school more affordable. By the way, Brooklyn Law School is not going to be inexpensive after this, but it's a beginning, and I hope that others will follow, and we're working on it, and it does relate. For me, this is a particularly gratifying moment. It's sort of a bookend or a bracket. Today's Brooklyn Eagle is talking about, Monday's Brooklyn Eagle will be talking about law and cyberspace in today's program, which is quite remarkable considering that, in the 1850s, Walt Whitman, as the editor of the Brooklyn Eagle, was talking about slavery and how wrong that was and the need to address that problem. And so now we're talking about law and cyberspace and the future and opportunity and all of that. But today's Brooklyn Eagle article is about our tuition reduction. It has a picture of me in it with my hair standing straight up on end, looking like the actor in Back to the Future, the mad scientist. I sleep in a tie, so it's one of the few pictures with an open-throated shirt, and so on. And that picture is from 2 years ago this week, your hackathon, which was the first Brooklyn Law School event I attended. I wasn't even the dean yet, but it sounded like a good idea to me, so I showed up and gave a talk, and so this is a perfect, full circle. So trying to make sense of today's program, not that it has to make sense, but what is sort of the coherence and big takeaway? And when you look at the program, and if you participate and get snippets of all these different panels, it's a little bit like trying to take a sip at a fire hydrant. But that's okay, because enough will hit in the right place to kind of make a difference and stimulate. We're not trying in any of these programs to give away the store. It's a beginning, it's not an end. And I think it's been very, very productive. But after all, there are 6 sides to cubes. There were 6 different panels, very different topics, although there were 2 related to raising money. And then, you throw the cube and it spins, and we had our, speed talks, which is kind of amazing to see that. And then right smack in the middle of the day at lunch, and I caught some of this, there was sort of this manifesto talk. It might amuse you to know that I had just gotten off a 2.5-hour conference call with the ABA discussing the upcoming 2015 tour in the United States of the Magna Carta. And so, the entire lunch theme was tracing, the origins of what rules do we establish, through whether they're laws or code, in terms of legal order when there's a vacuum, but tracing it all the way back to Magna Carta. So it's kind of apt that I would come from that clunky ABA discussion and hear folks talking in terms of cyber manifestos and so on. So it was really quite a remarkable relevancy for me for this discussion. This panel is extraordinary. In particular, I've looked up to many of the people who are here. I heard Beth, both in her comments and in the very last comment that she made, really make comments that distilled what CUBE is all about. And that is when she said, and I'm paraphrasing, that about lawyers being in at the beginning and not just later on. In other words, what CUBE is about is preparing young lawyers to be in at the takeoff, not just the crash. And when you look at new ventures and new enterprises, so many of them fail. For kind of classic reasons, but one of the reasons is that they're not not infused with legal DNA at the start. And that really helps. But they don't, understandably, because first of all, their vision and the lawyers that they have known speak in a different way. And what CUBE is about is giving people experience working with entrepreneurs, working on new projects, working on new ideas and new ventures, whether in a large or a small organization, and working with this evolving new culture that has been described in this panel today. And learning how to say more than no. You learn how to say here's how, or why not, or did you think about this? And that kind of approach to law. And so I think it's incredibly important. I think this is a very successful and appropriate beginning of CUBE as our first symposium. It is a wonderful start to something that only began this year. People ask me what CUBE will look like next year and the years after. I can tell you truthfully, I have no idea, and I don't even want to know. It's going, and I say this to people, and traditional academics get a little uncomfortable. Lawyers get uncomfortable. My board looks on me when I say this the way that I think the Reagans looked on Ron Reagan's ballet career. You know, they're officially proud, but privately they're a little nervous and don't know what to make of it. But when I say the following, we are building the plane while we're flying it. CUBE is not a 20th, 19th, 18th, 17th, 16th, 15th, or medieval model of an academic enterprise. CUBE is a 21st century academic enterprise. Our funding for it was not, the approach was not to go out and raise $25 million and then live off the endowment and plot ahead. Our donors who are successful, our founding donors who are successful entrepreneurs themselves, damn it, want to hold our feet to the fire. So they only gave us enough funding to last for 18 months. And then to see what we really need, what we're doing, and to evaluate how we were using their money. Every one of our founding donors had the capacity just to kind of give us a big bundle of money and to move forward. So they've actually put us to the test. So I hope that in these concluding remarks that they're not only appropriate, but they kind of somehow give you a feel for what we're about here at Brooklyn. We are making a lot of changes. We're moving ahead. We're having some fun while we're doing it. We're doing things consistently first for a bunch of reasons. I heard a lot about agile. We're nimble here because we're an independent law school and because, as you know, a lot of us don't necessarily come completely from the traditional academic background. We don't know any better. So we're just trying to move ahead. And also in Brooklyn, we're a little impatient, you know, in terms of waiting. So that's why we're a little restless. We're not afraid to have something work out. We have the confidence to know we can learn from things that don't work and move forward. And so in that way, the whole vibe here at Brooklyn Law School is very much consistent with what CUBE stands for and what all the people who participate in this conference stand for. Thank you very much for coming, and I hope that Jonathan takes you to an appropriate pub or bar, or if you're really shortchanged, you know the back room in my office will take care of almost everybody in this room. Okay, take care.
Thanks everyone for coming. I think we're well over, so hang around to mingle or move on as you please.
Oh, now that you point it out, I see. That guy?
I need to know the sociometrics of how his family's
But I think minus